All right. Good afternoon, everyone. Quorum is present. The September 21st Board of Health meeting is now open. Just to remind you all that this meeting is being audio and visually recorded. First item is public comment. Are there any comments on any issue that is not on the agenda? Okay, hearing none, we'll move on to the approval of the minutes for the August 17th meeting. Those were distributed previously. Does anyone have any comments, additions, corrections?
I move approval.
Second.
Any further discussion? All in favor of approval of the meeting of September or August 17th, say aye.
Aye.
Chairman says aye. Next, we have a waiver of a fee. Roberta, you want to explain this to us, please?
Yes. So the property is owned by the town, 3 Shadbush. There's going to be some work being done on the town, septic work and a well. So the town is asking that we can waive the permitting fees because it's a town project.
So you don't want the town taking money from one budget and putting it in another budget?
We can create the paperwork that's going to cost more. That's going to cost more than the actual permitting fee.
Okay. Any comments on that? Can I hear a motion to waive the fee, please?
Second.
Any further discussion? All those in favor of waiving the fee?
Aye.
Chairman says aye. We have an ACO for 47 Starbuck Road.
It's a standard ACO moving forward, looking to do a boundary repair in preparation for the possibility of sewer.
Any questions from the board? Any comments? Do I hear a motion? No motion?
Motion to approve.
Second.
Any further comments? All those in favor of the ACO for 40 Starbuck Road say aye.
Aye.
Chairman says aye. The ACO is approved. We have a variance request for Regulation 64 in Title 5 for 123 Winnett Road. Roberto, do you want to explain this one to us?
I have to accuse myself from this.
Go right ahead.
So this is a waiver request for the requirement to put in an IA system here. The property owner is trying to do a renovation. No, Ms. Williams is here representing the property owner. He's looking to do a renovation to the bathroom, including a bump out that's going to add about 90 square feet or so.
That's you, yes?
About 90 square feet or so. It would trigger the IA regulation because it is a undersized lot. It is only about 3/4 of an acre, and it's a 4-bedroom system. And then the most recent inspection that we actually got in today from George says that it is actually failed from separation. So, and if they want to add anything.
Well, just a second, a couple of questions. The system has failed, and it's an undersized lot.
It's
Even for the present?
Yes, it just we just got the inspection report in that says there's a lack of 5-foot separation.
So it's a separation issue.
Yeah.
When it was put in 1992, they contracted...
Just please introduce yourself.
Linda Williams for the applicant. When it was built in 1992, they showed that it was about 4.2 feet, I believe is where he ended up.
Something like that.
With the groundwater separation.
Yeah.
And it was signed off by the health department, and off they went 25 years ago. You weren't probably in diapers, Hartel. But it was signed off, and off it went. So nobody said anything since then. They've had it pumped out here and there. They're there for maybe 6 weeks of the summer. No one ever brought it up, and that's why we had a inspection done at Roberto's suggestion, because it had been such an old system.
Yes.
And apparently it is in violation of the separation. And they have a mounded system there now, and we'll have to either go to a tight tank or find out if we can do an AI there, or an IA there. But we've got 2 years to fix it.
Now that this is outside of the watershed, right?
It is. It's
So,
across
yes.
the street,
Yes.
thank goodness.
Yeah. So I believe you have 2 years from the
But I
failure.
think it's
Okay.
going to come in within Concom's jurisdiction first. You have to deal with them first, and
Yep.
then whatever you need from us, from the engineer, we'll have to see what he's looking for as far as variances.
It could be a tight
sideline
tank.
setback or anything, right.
Yeah, because a lot of people, George services a lot of people on that strip. He says he services a lot of tight tanks.
But that's a last resort. If the engineer could fit something in there,
Yeah,
then
more power to us. But the addition is to expand, what Berto said, it was just an expand an existing bathroom so you can actually stand over the toilet.
But let's go back. It has 4 bedrooms?
I believe there's 4 bedrooms in the home. I believe it was 4 bedrooms.
Yeah.
I don't have the
But
permit
so
here.
it's an undersized
Oh.
lot for 4 bedrooms?
1992.
Yeah.
it's serviced by the
Yes,
wall
4
winner
bedrooms.
towns, almost like the wall winner provides all the water
Water.
for people out there. So it's like having a municipal water service, so there's no wells.
Yeah.
There's no wells?
Yeah, there's a it's considered a public
Public.
water supply, and it has a 4-bedroom system on the lot. And the square footage of the lot I have here, which for some reason I can't find it now. I think it was it's the 2 lots together. I think it's because there's a subdivision.
They own all the
So
way to the water.
Yeah, so the 2 lots together come out to about 3/4 of an acre.
Questions from the board?
And the original.
Maybe for Roberto, the way I interpreted the letter from Jeff is that this needs to go to Concom before it comes to us.
So any work that's going to be done, if there's going to be any, because it's a coastal dune area, so if there's going to be any repairs or anything like that, they do need Concom approval
Yeah.
first.
So what's before this board today?
The request? Would you like to?
It's just the extension of the existing bathroom over the piers. There's already an existing stoop there. It's going out over the stoop on piers, so they can get a little bit bigger bathroom.
And they're requesting that they do not have to put the IA in right now.
Because of the expansion.
Yes.
We're going to have to do it anyway under your rules and regulations.
So you will be putting in an IA system?
Whatever the engineer says we can put in. If not, it'll be a tight tank.
Art?
So anytime somebody comes for a building application or a building permit to do work on their house, we have to sign off for septic approval. Septic system has failed. It's the as-built plan shows it 4.2 feet from groundwater. I was out there with an engineer in April to do a repair plan for it. It shows that it's roughly 3.3 feet from groundwater. For us to issue a building permit on a failed septic system, it's like the cart before the horse. You take care of the septic issue first, and then, or get the permit for the septic repair, and then we can approve the building addition. Otherwise, we'll be chasing them. So
Makes sense.
my recommendation would be to just follow the process as we usually do, have them get a septic permit for the repair. They'll bring in the application.
So the
we'll sign
logical
off.
thing is 2 options, say, if we turn down the variance request, or they could withdraw the request and go ahead and get the septic done and then come back here,
Yeah,
something like that.
I can tell you the engineer for this one is going to be in front of this board for variances, as well as for Concom. So the engineer really should be here speaking on the variances because he's the guy who knows, or a girl who knows.
So my sense is we're not prepared to grant a variance at this time.
But they could withdraw it, and then they wouldn't have the,
Yeah, you could withdraw it now and go back and,
so it doesn't look like it was not approved
Right.
or something.
yeah.
I think
you
it
don't-
would be prefer to withdraw it.
Yeah, go
and
ahead.
Figure out where we're going to go next, and I'll
Yeah,
get
the
Bracken back
information's
out
too
there
new.
because Bracken did the original survey. I think it's closer than 4.2
So you have
feet.
officially withdrawn it and go figure out your septic system, and if you need to come back, come back.
Yeah.
Okay.
Yeah, the new inspection was kind of a bombshell. It came out these last 2 days.
Yeah, I didn't get it until last night either. And it's
Yeah.
like, and that's I said, you better, is it down at your office? And they said,
Yeah.
yes, he turned it into their office. Artel, you mentioned a repair. Is there no way you can't repair this old system, right? So it meets the groundwater, you have to put a new system in, correct?
Yeah, new leach.
Okay.
Yeah.
So that
you-
would be the remedy.
It'll be an IA or probably an IA.
It would probably most likely be an IA if they can fit it on the lot.
If they can, they already
Yeah.
have a fairly sizable mound for the system that went in 92, which was interesting. But it was all signed off, and they didn't know they had a problem until I asked them to do a new inspection.
Okay,
Thank you.
thank you.
Thank you.
Want me to sign something?
No, we're good.
Okay.
Thank you. All right.
Now we have an appeal for the condemnation of 22 Hawthorne Road, which we condemned last month.
Yes. So this is an appeal of the vote that we took last month. Last month we brought to the board the information about how this system has been in failure for a number of years, and then based on a recent complaint, we did visit the property and we did see breakout on the property. So we asked for the
Right.
condemnation from the board.
Mhm.
We sent the letter, and there's an official appeal.
Okay.
So,
Michael Pearson, attorney for Amy Peering, the owner. I think the first question I'd like to ask is the conditions of the hearing here. Is it an appeal? And if so, what are the rights of the appellant? What are your duties? And under what regulations is the appeal being held? I'm not trying to be funny here, but it's a legal matter. Ms. Peering faces further fines, further penalties, if the matter is not dealt with properly. So I need to know, as a matter of law, how this appeal is going to be held and under what rules and regulations.
may I-
Go ahead.
The condemnation hearing is done under the State Housing Code 105 CMR 410. This section specifically is 105 CMR 410 850, which is the right to an appeal. This appeal is we give you your time to give substantial testimony, your grounds, reasons for the appeal. Then they will be open to public comment, and then there will be some deliberation.
So the appeal is basically under 4110.
410.
Is that correct?
105 CMR 410.
Yes, and so basically the condemnation should have been held under the same provisions.
The condemnation was held at a public hearing at the Board of Health meeting.
There was no notice of the public hearing. Sorry, let me just interject. First of all, the letter that was sent out on the 20th of July was totally inadequate and just incorrect. Secondly, if you look at 410, you have to go through a number of hoops before you can even get to condemnation. And none of the procedures in 410 were applied at all. Let me just give you an example. The 20th of July was the first notice that the appellant had. And let me read, I've got copies of the letter, perhaps I can pass it out if you need it. But let me read it for the record. It's from Mr. Crowley. Dear Miss Peering, this department has not received a copy of a pump contract that you are required to provide per the 12th of July correction order issued to you regarding your hydraulically failed septic system. The correction order required you to provide this department with a copy of a pump contract within 7 days. Unfortunately, you leave us no choice but to issue a ticket for non-compliance. Each day's failure to comply with this requirement is a separate violation. This ticket is payable to the town clerk's office at 16 Broad Street. This property will be on the Board of Health agenda August 17th for condemnation. And this is important. Should there be no action to correct this violation? In this letter, as again I've got copies of it, the violation complained of is the failure to produce a pump contract. Very plain. That pump contract was supplied the following day. So that was in July. Nonetheless, a hearing was held on August the 17th in respect of that. So if it was about a pump contract, I think Mr. Santa Maria can confirm, the pump contract was with the Board of Health the next day from George Hughes.
We do not have a record of a pump contract. We do have an email that just says that he will be pumping,
I
but
spoke
there's
with
no
Mr.
repair.
Hughes today. He said he'd sent the contract to the Board of Health.
We have no file of a contract at all in our file. We have no record of a file of a contract.
Right, well, I'll have to take that up with Mr. Hughes.
And then
Nonetheless, moving on from that, the procedure for the hearing, there was no, first of all, the letter here saying, should there be no action to correct this violation, that is not a mandatory letter to appear before a board. It's should there be no action taken. But moving on to the provisions contained in 4110, first of all, before you can condemn a property, and I've got the copy of the law here, before you can condemn a property, I don't know if this has been the practice of the board, you first have to hold a hearing. And the hearing has to be in respect of finding that first the property is unfit for human habitation. That has to be a finding. And prior to doing that, the property has to be identified, a statement sent, a statement about the condemnation, a statement about the time and place of the hearing, and also a report attached in connection with that. Most of those things weren't done. So the hearing, in terms of condemnation, was faulty. It basically should have been a hearing to find the property unfit for human inhabitation. Because E, where the power to condemn comes in, says this: at the same time or at any time after the Board of Health issues a finding that a dwelling or portion thereof is unfit for human habitation, so there has to be a finding of unfit for human habitation, the board may issue an order condemning the dwelling. So you cannot condemn a dwelling until you've found it unfit legally for human habitation. And that has to be done in a proper way as laid out in 4110. That wasn't done. So that negates the whole hearing in terms of condemnation. There's a proper procedure laid out, wasn't followed.
I think we.
I can give you the relevant law, but 5 or
Well,
6
go ahead.
copies.
Go ahead.
So, as I understand, this is a hearing for you to come and present your case as to why this shouldn't proceed. And what I hear you is objecting to the administrative process that we took. That's your legal opinion.
No, it's not my legal opinion. It's written down here. So.
Don't please, would you please not interrupt? You know, I kind of lost my train of thought with your interruption, but so we, you know, you've rendered your legal opinion, but haven't spoken to the issue that really is the purpose of this hearing, and I'd like to hear that. The legal process aside.
There's nothing else to say. You didn't follow the legal process. It's illegal. You cannot condemn. Would you like a copy of the relevant law so you can read it? It's very plain.
This is an opportunity for, as Roberto said, for you to come up and tell us.
Well, as I say, I mean, I'm just going to
Excuse me,
repeat.
I should not to interrupt, so I'm finished.
Well, I sort of have this. I was going to say the same thing. I'm not a lawyer, but I'm a health officer, and I'm more concerned about the condition of the property. And you don't seem to have any concern for that.
I've got great concern. Let me tell you why. Because I contacted Mr. Crowley over a year ago in connection with these properties and discussed the matter. I actually live at 22. My wife and the property we're discussing, 24, belongs to her sister, would directly abut each other. So we have a similar problem with our 2 septic systems on the lot. So I spoke with Mr. Crowley over a year ago about this, and we did take steps. In January of this year, or slightly before, we actually went to the engineer, Jeff, I forget his second name. Yes, we went to Jeff Blackwell in January with the septic reports. He looked at those septic reports, and he came up with the idea of joining on to the Dukes Road sewer. Now, I've got a map which shows the proximity of our 2 properties to the Dukes Road sewer. It's not exaggerating to say it's yards away, probably less than 100 yards away. So, I'm sorry, I don't know, people are leading by not shaking their heads backwards and forwards, but So anyway, we went to Mr. Blackwell, and he came up with the idea of linking in to the Dukes Road sewer. So we followed quite a merry dance for quite a while. We went to, I believe we contacted the Board of Health. We were invited by telephone, invited to go to the sewer department. Went to the sewer department, multiple meetings with David Gray. David Gray passed us back. We had telephone calls with the Board of Health. We've also spent $1,000 on a wetland survey for conservation committee, the conservation aspect of the matter. We've been down to speak with the gentleman Jeff at the conservation committee in terms of getting a permit to go through the wetlands there. He said that probably they would allow that. We had a meeting with Eric Savesky of the land bank about getting easements over various properties. So for the past 6 to 8 months, we've been very active in pursuing joining, hooking up to the town sewer. Now, what I would like to point out is, I think all three people are sitting here. We sent emails, and I've got them here, to Kathy asking about joining the town sewer. And the response, and I've got them here, is we're not sure if you can join in. We will get back to you. She's sitting here. Can you ask her if she got back to us? The answer is no. Just recently, we sent 2 emails to Mr. Santa Maria there, asking if there was any known reason why we could not join the town sewer. Mr. Santa Maria, what was the responses? No
We
response.
spoke by the phone.
No response.
We spoke by phone.
No
Mr.
response.
Pearson.
You spoke to me on the phone?
You spoke to my department by phone. I asked
Not
my
after
staff.
I sent you 2 emails, or at least I sent
No.
you 2 emails. No response.
let's-
So, well, don't interrupt me, please, sir. Thank you. So we've done quite a lot in the past 6 to 8 months to pursue hooking up to the town sewer. We've had no help whatsoever from the Board of Health. Nothing. I've got the emails here. No responses. Kathy was saying, I'll look into it for you. No response. 2 emails to Roberto. No response. So when you ask us what we're doing and are we taking it seriously, we're taking it very seriously. Because Jeff Blackwell has said it's probably a cheaper option for us to join on to the town sewer. And from what we understand, most of the people in the town want people off the septic. We're in a wetlands area. We want to be on town sewer. So we've pursued this diligently.
A lot of comments here. Roberto, maybe you should comment.
So first, let me address the issues of procedural and offering something as unfit for habitation.
Okay.
105 CMR 410-750, conditions deemed to endanger and impair health and safety. And I'm quoting the law right here, that because of 410-100 through 410-620, state minimum requires that minimum fitness for human habitation. The following conditions will be considered immediate impairment to human habitation. Section, let me see right here, Section F, failure to provide a toilet and maintain a sewage disposal system in operable condition. The letter of May 6th, 2015 specifically says that the system is not functioning. That alone is a finding of unfit for human habitation.
It's not.
Under the state housing code. So we found it unfit for human habitation 2 years ago. And when the work had not been done, that is considered inadequate amount of work. So the second notice of July 20th came where we specifically said it is on the agenda. It is, you chose not to show up to that meeting.
Because the letter said, unless action was taken. You received an email from George Hughes. We were told a pumping plant had been put in just today by George Hughes.
As the representative for the owner and as a person of the law, is it negligence of the law is considered a defense to the law?
Negligence of the law?
Yeah,
I
just
think
because you
it's- I
did
think
not
it's called
know.
ignorance of the law.
Or ignorance, semantics? Is that
I
a
think
defense?
it's ignorant not to reply, and from the Board of Health, from all of you, not to...
Well, here we
Okay.
go. I mean,
Okay. I think I'm done.
Art, you say, and then I will summarize. Art, would you like to comment?
Yeah, I'd like to make a quick comment. They did contact our office regarding sewer. Kathy handled a lot of it. Some of it I did. There is no sewer in front of their property. The nearest sewer is 700 feet down on Dukes Road. Now, from a financial point here, when you look at the Dukes Road, what it cost them to run that line, it was $100, I think, a lineal foot. So there'd be $70,000 for them to go from their house to the Dukes Road connection. The septic system's going to be less than that, and probably, yeah.
Is it in the sewer district?
It's in the sewer district, yes, they're in the sewer district. So the cost of the septic system is going to be less. We're trying to think about this financially for them. We've asked them to, come in and get into the loan program. They haven't come in front of you to get into the loan program to fix this. There's a lot of going back and forth about sewer and septic and sewer and septic. Well, if it's not in front of you and it's not cost effective to run the line, the point is you got to do something. Hire somebody and go on a path. Show us you're making some progress. We haven't. We've just been arguing like we're arguing here today. And instead of some action on this in a direction and moving forward and solving the problem. And the board has the money. We have the money to loan them to get this done. We can't loan them the money to run this thing 700 feet. We can only loan it to them for their property to run it out to an existing sewer line. That's not what the loan money is for. So the other direction would be 1,200 feet to a sewer line that's not even there, which would be $120,000. So anyway, that's...
Thank you.
I'll just respond to that, sorry.
You're going to respond, then Jim's going to respond, then Roberto's going to respond.
That is absolutely incorrect, what he's just said there. I don't know if he's a qualified engineer. We've had costings from Mr. Blackwell. Mr. Blackwell has suggested it would be significantly cheaper for us to pursue the Dukes Road option than to put new septic systems in. So he's an engineer. He's actually given us prices for that. And the reason for any prevarication is not on our part. It's on the part of the health department, because we did not receive any help from them. From January of this year, we have been pursuing the sewer option. We told you that. We went to, as I say, David Gray, Eric Savesky, went to Concom. We spent $1,000 of our own money getting a conservation committee plan. Is that doing nothing, spending $1,000? So we've been told that's the cheapest option. And if I show you the letters, we've been actually begging these people, if I show you them, do you know of any reason why we cannot join the town sewer? Please tell us, because David Gray said there might be an issue with some easement. Ask the health department. We sent letters out.
Well, I don't think the health department does easements.
Whatever it is,
sorry.
I appreciate that, but whatever it is...
You would have to go over 3 properties, as
Yes.
I look at the map, to
Yes.
get easements.
Well, as I say, we've asked... The only reason we're off at the moment, the idea of the sewer, is because of the actions of the health board. They knew back in July that this was the option we were going down, but nothing from them.
Well,
let me ask you this.
I'm sorry,
There's
but the
also-
health department does not build sewers or issue
No, but there's
sewers.
also the provision within the Act, I'm sure somebody has got it, and I've got it, for the health department to extend, I believe, up to 5 years, if there's the possibility of joining on to a sewer system.
Well, it's
not
your
necessary.
system. The system you're representing is not just needs repair; it needs total replacement because it's a hydraulic failure.
Can
I
I
mean,
just
there's
speak?
material in the yard, so in no case would we ever give you any kind of variance, some time to repair it. It's a health issue now, and has been for 2 years. Jim.
So, we have a I would call a crisis here. We've got raw sewage out, and I think we have a public health concern that we have to deal with, and I think that's the issue that's before us today.
It's my
not,
issue.
Not who said what and who didn't call back and what did somebody allegedly say, and so that's all. I'm not sure the legal term is hearsay, but we don't have, and I don't think we should spend the time. We're just chasing ourselves.
Yeah.
But I would ask Roberto, it's my understanding that if a citizen wanted to add their property to a to existing sewer, they prepare a citizen article and come before a town meeting, and then you go through a process of scoring that.
As
And
if they're not in the district only.
But
Is
they are in the district, but they are not in one of the needs area. So the ACO, the 5-year
right.
that was just alluded to, does not apply. This needs an immediate repair.
Yes, it
No,
wouldn't.
I'm just talking about, forget. I'm off the immediate
Okay.
repair. I'm saying is because their argument is, well, we just want to tie into a sewer, and I think that's, to me, is kind of I won't call it a red herring, but it's kind of a screen for really what the issue here is. But I thought the way to tie into the sewer is through.
Yes, that's if you're not in the sewer district.
Okay.
At some point, for some reason, this property and the neighboring property
Right.
specifically have been added to the sewer district, but no other property around it has.
You know how it got added? No.
Only by the vote of town meeting. But in my conversations with the sewer director, the feasibility of this property connecting to any of the existing sewers is
So
not,
could we do
almost
some
non-existent.
research on how this got? I mean, did the citizen bring it forward to?
It had
go
to
into the
have
sewer?
been brought up by a citizens warrant article because
Oh,
it's not
okay.
part of the needs area.
Okay, all right. So was it approved? It must have been approved.
It had to have been approved. I don't know how long ago it was.
Okay.
It was definitely before my time when it got
Okay,
approved.
Okay.
You want to comment, then we'll make the decision.
Thank you. I don't want to, for the record, Paul Santos with Nantucket Surveyors. I don't want to get in the middle of all the condemnation and so forth, but I just want to bring you up to speed on where I've been contacted and where I'm at. I have a contract with the proponent to deal with the system on site as a repair, nothing to do with the sewer connection, because that's a long-term, and I've told the client that the sewer connection is a long-term solution. The immediate solution is fixing the problem that you have on the site. So I was contacted by Jeff Blackwell. I've spoken to George Hughes. And Jeff contacted me because Nantucket Surveyors, Inc. did the original septic system on the lot some years back, and he thought it would be more cost-effective if we came in and modified our plans than have Jeff draw new plans. So I have a contract with a proponent. I'm willing to fast-track a visit to the site, a look at the existing system, and a repair solution on site to deal with the issue that before the board and that the owner has. So that's if you want to put a time frame on, I'm comfortable with a 2-week, a month, whatever you're comfortable with. I have no problem with jumping in the middle of this thing and trying to solve the problem on site. And then, as a long-term solution, the sewer can still be looked at because there's some other properties that can be tied into the sewer. But I'm talking specifically about 22 and trying to come up with a solution for fixing this, Band-Aiding and fixing the situation that you have out there right now. So that's what it is. If, like I said, if you're comfortable with saying, listen, we want some type of solution or something within a 2-week, 3-week, or 4-week, if you give me a little time at least to let me dive into it, I'm happy to agree with anything that you may have on behalf of the owner.
Yeah, go ahead, Jim.
So what's a temporary on-site solution?
Not so much temporary, a solution to the on-site.
And what would that? Give me some.
It would be either a new leaching trench, let's just say a new leaching trench in a different spot, or an examination of why the system that's there now is failing, whether there was a reason for it. And that's what it is. So I'm not saying a temporary solution. I'm saying on-site Title V compliant solution to the problem.
But I thought if it failed hydraulically, you can't repair it. I thought.
You can repair it by putting in a new leach field or a
Okay,
new
okay.
trench or something.
But I just have a little bit of relevant
Yeah.
information. It's believed that a truck backed over part of the pipes and crushed the pipes. It's a relatively new system. I believe it was put in 2003 or 2006. It's not an old system, and it's believed that part of the piping was crushed by a truck.
There may be a solution, but I'll tell you what upsets me. Why wasn't this done in the last 2 years when this issue first came up?
Essentially, we've been looking at the sewer option.
Yes, but you were looking at the sewer option, which is a long-term option.
Well, we
This
don't
is
know this.
excuse me, sir, this is an opportunity to get it fixed. All right? The sewer is a long-term option with low probability. having somebody come in and see if it can be repaired seems to me is something that should have been done in the last 2 years. That's why I'm getting a little crazy here.
Let me get a little bit crazy, because you are imputing to us all of the knowledge that you have over the years of doing these systems. We don't know that 1% of what you know. We thought maybe the the sewer solution would have been reasonably prompt. We didn't know how long it's going to take. That's why we're running around to all of these agencies.
Let's go on.
Excuse me, but the length it takes the time for the sewer is nothing to do with the Board of Health. You have a problem, it's your problem to go to the DPW and say, we want to tie into the sewer, how long will it take us to get into the sewer?
We didn't know that.
Excuse me, if it's possible. And they would have to give you some kind of an answer. But in the meantime, you have to fix the problem that you have.
And we thought we were going to fix it by joining up to the sewer. Like I say, you're
but
all
that was
imputing.
years
Excuse
ago.
me,
All right,
sorry.
all right. We're going
You're
around.
imputing to me all of the knowledge you've
Okay,
got.
let's going around in circles. Let's everybody sit down and let the board discuss
Can I
what
say
we're going to do.
something, please?
One quick, very quickly.
We only recently found out.
Would you
that-
introduce yourself, please?
Oh, Lisa Bouchard, Amy's sister, who lives next door. We only recently found out that she did have, in fact, a new septic system put in either '03 or '06. And if she had to get a new septic, it would have been $50,000 to get a new septic put in. So now we're finding out that it may just be a repair. So we didn't know this a year ago. We only just recently found out in the last few months.
Thank you. Comments from the board? Suggestions of where to
So
go?
this has been going on for a long time. We have a public health hazard.
Yes.
It is consumed not only our time, but even more so the time of the staff. As a property owner, I have an obligation to either have the exquisite knowledge, which I don't, or make sure I have experts that do. And so I don't see a reason to extend extend a waiver to them, because we've been talking about this for 2 years, and that's my personal view.
Well, we have a situation that we can give him an opportunity to get this fixed right now.
Well, we did that last time.
No, I'm saying that he just said,
No, I know, but we said, and earlier we said, well, you have 2 weeks to fix this. We gave them timelines, and nothing happened. So we've given them that. We've already done that, and it was a result of that of nothing happening, regardless of the reason that we're here today.
So if it's repaired, then what? Sorry.
No.
Once it's repaired, once the system's working, that's
It's
the
fine,
only...
we can all go home.
Yes.
Steve, your comments?
The 2 years is a little, that was plenty of time to get things done, but I do understand how this island is so crazy. We can't, and Paul knows, we can't even get guys to give prices on repair plans, new septics. It just doesn't happen overnight, so I would be inclined to, do what, like Paul said, if he's contracted with them, and maybe give him a couple weeks to get a plan.
You're being kind, but
Yeah.
maybe for the wrong reasons. My concern, I understand this house has tenants in it. There are people living in this house.
Oh, boy.
So we have a very unique situation here. We have an urgent public health issue.
Wow.
We do have the pumping records, but no contract.
But then if we condemn it, then we have a homeless family.
Unfortunately, yes.
There would be other option to cite them criminally, and
That's
then you would
the-
be obligated to find a home for those people. That's a
Yes.
third option.
Yes.
How long would it take you to make an assessment of what needs to be repaired, Paul?
Fast track, I can do it in 2 weeks. I'll
Can you look at it
I'll be on site next week. I'd like to get on site next week and actually look at them.
Can you get on site before next week?
Yeah.
Before next week.
Tomorrow's Friday.
Tomorrow.
Well, tomorrow is
Tomorrow.
Friday.
That would be tomorrow.
I'm sorry.
Yeah.
It'll be
Yeah.
next week. I can get on site next week.
Can you give us a date when you will have it figured out, what has to be done?
Yeah, I think we can figure it out when we're on site. We're
Okay,
going to
well-
know when we're on site, and I'll have the Board of Health with me.
Yeah, it's
You
a
know,
watershed.
We need a
next
But
date.
this-
So
but
we'll
this
be on
has
site
been-
next
this is
week.
what- I
I'll
mean-
coordinate with Art having a site visit out there. I mean, I'm going to need a machine. I just need to take a machine out there, you know, and have Art come with me. We're going to dig up that existing, both ends of that existing trench and see if it's plugged on the front end, the far end's going to be clear. You know, we'll try to figure out what's going on. If not, then we have information in place. Jeff has provided me with what he has done. He did a test pit, he did a perk test. So I have, if I know that it's not a quick fix repair, I have enough to do, then to turn around and design quickly. So,
But then
in
we
2
still
weeks, we
face
can
a
have
problem.
everything taken care of.
We still face a problem to get someone to do the work.
Yeah.
We as the board, or you as the board, have the authority to set a timeline, a specific timeline to say the system has to be functioning by X date.
Again, it's their problem, not ours.
It is. It's
Okay.
a health problem.
So-
But we also have a family that may be on the street.
Well, it's a public health, I think public health problem trumps housing. These folks maybe should put them up at a hotel. That's their route,
Art, you have a comment. Then we'll,
If you're going to go down the route of Mr. Santos providing you a plan within 2 weeks, I think there needs to be another date for completion, and then then there's no more leeway. Giving them every opportunity to get this done. They've got a pumping contract. The issue with a pumping contract is the more they pump, the less money they have to do the installation. So this needs to get done soon. It's to their best, advantage as well as it is to ours.
Is the system being pumped out now?
Yes.
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 Could we ask them for money in escrow for the cost of repair to make sure that it's going to be done? Can we do
I
that?
don't know if we have the authority to require
Just
escrow.
asking.
But what we can do is definitely set the time, and after that, if we were to say 60 days or whatever, after that day, if we can pursue criminally after that.
60 days is too long.
But we've already,
By next meeting.
That's 4 weeks.
That's,
And we could have a special meeting earlier if we wanted
Yep.
to.
I was just thinking the time for Paul, and then, maybe I'm sure we could
we can
pull
get,
some strings to get somebody to do it.
Yeah.
yeah.
Sorry, is this
I would say
hearing-
I can get you a plan, I can do it, but I can't effectuate the paying for it and getting it in the ground.
Right.
Yeah.
I'm sorry, is the hearing
That's
over?
gonna be
Because Mr. Crowley's keep interjecting.
We're still discussing the issue.
But is the hearing over? I mean, are you now deliberating?
We're deliberating.
Okay, so should be no more evidence or input from
There's no more evidence. He's a staff member giving us advice. It's not evidence.
Mr. Sutton?
It's not evidence. It's advice. And if you would listen to us, we're trying to help you here. Because if we didn't have this advice, we would deny your request. We're trying to come halfway here. So I would appreciate that if I were you. All right, now,
A date.
a date. Reasonable date, but
It's
not,
got to be a date. We need a date, and that's it. And that's the end. After the date, if it's not done, then we charge them criminally with something. We force them to move the people out of the house and put them up wherever they have to put them up. It's gone on long enough.
it's gone long enough.
So could,
Go ahead, please, Jim.
Roberta, can you talk about language we could use that had a date and then reference about the criminal and all that kind of stuff, or maybe you want to get legal counsel to.
No, legal counsel has already reviewed this case. I requested legal counsel when the appeal came in, and it is the opinion that we can set a date of when the system will be a certificate of compliance issued by a specific date, which is what we have the authority in. So I would
And
suggest
if that doesn't happen,
we can
tell me the process of the criminal.
From then, we file a criminal complaint with the Superior Court to pursue the property owner criminally for not adhering to a Board of Health order pursuant to 105 CMR.
And do we need to have any?
594.
Do we need to have any more meetings about this or hearings about it, or is there another?
We don't need to have.
Is there another appeal process for
Nope. The only other appeal process allowed through the decision of a Board of Health is at the Superior Court.
That's the next step up. So if we said that we'd have to have a certificate of compliance
By
the next board meeting,
it's October 19th is the next board meeting.
but that's certificate of compliance would be all repaired.
A certificate of compliance is a fully functional system.
4 weeks. That's not a lot. That's better than 6 months.
Yeah.
And then if by the next board meeting we don't have a certificate of compliance, we will ask for criminal charges.
Yes.
So do we have to? Can we put that in our motion today?
Yes.
That criminal charges will be
Pursued.
sought or pursued,
Mhm.
or
Yes, you can put that.
so I'd make a motion that.
Well, wait a second.
Okay,
What-
sorry.
And the specific criminal charges are
Not adhering to a Board of Health order.
not adhering to a Board of Health
in accordance to 105 CMR.
Or, but
410.
there's a law about putting people at risk.
Yes, Massachusetts General Law 111, Section 122. It
So,
is
so there's two potential criminal actions here.
yes, yes. Not pursuing, not adhering to MGL 111, 122 is actually considered a criminal negligence case.
And that would be
jail time.
that would be not obeying our request.
That's a state law.
Okay.
Now, does this need to be in writing with a copy sent to them?
We will do a full write-up, and we will send it certified and
Right,
mail,
perfect.
and general mail, as well as email.
So in essence, we would need a motion that we need a certificate of compliance by October 17th.
19th is the Board of Health meeting.
19th. If we don't have it by that time, the property is condemned, or we've already condemned it, so the
You might
property.
want to maybe a day or two earlier, because if we have, the end of business on the day of the meeting, it could be 5 o'clock, and we could be.
So it would be
maybe
the 17th is the meeting, so we'd make
Then-
it the 15th.
Yeah.
The 19th is the meeting, so we can do it
make
the
it the
18th.
15th.
The 15th
No,
is
the
a
end-
Sunday.
The end of business, that Tuesday before that Thursday. How's
It's the
that?
17th.
That's 2 days to dance.
Yeah. Okay.
So, Roberto, let me ask you a question. If it comes and it's not done, and we charge them, whatever we do, how long does it take to physically move the people in that house out of it?
Once a house is considered fully condemned, the police are allowed to forcibly remove the occupants
So if
immediately.
it's not done, we can force them, we can tell the people they have to leave, and we can force the owners to find housing for those people.
Or at least reimburse them for.
So can that
Lodging.
be in the letter?
I would request legal counsel first before I put
Just
that
so
in a
there's
letter.
no misunderstanding.
Yeah.
Okay.
Okay, so I think we have a consensus of the board. I'm not totally happy with it. If it wasn't for your renters, I wouldn't do this.
Yes.
That's the way I feel. So I need a motion. Jim, you were starting to make one.
So I make a motion that we delay filing criminal action until October 17th into business, by which time we must, the director must have the physical certificate of compliance in hand.
By the 19th.
17th.
17th.
And everything else we discussed in the letter and writing sent to them, registered mail.
Yes.
Right. Do I hear a second?
I'll second. Yep.
Further discussion? All in favor say aye.
Aye.
Chairman says aye. So be it. You will receive those letters.
And Mr. Chairman,
Go ahead, go ahead.
You know, I worded my motion to really put the emphasis on delaying the criminal proceedings.
Yes, I think that was
purposely.
a very well phrased motion. Okay, now, as I recall at the last meeting, we discussed perhaps modifying regulations 72 and 73, and that we would hold the public hearing on such in October. And the purpose would be to upgrade our smoking regulations to make sure they were up to date, to make sure that in some cases where marijuana was mentioned or not mentioned, where maybe some of the scientific quotes were not correct, that it needed to be updated. So Roberto has drafted one.
Yes, but before we start discussion on that, it was brought to my attention by the town manager today that we actually have a bylaw prohibiting smoking of marijuana within town premises, any town property.
No, we do.
Yes. So I am looking it up right now. So it would adding this to our regulation would be redundant.
It's funny, I went to the police department, Roberto, and asked them if they had anything on file, and they said we have nothing.
Yeah.
So,
Yeah. Let me see if I can.
all right. So you already cannot smoke marijuana publicly by bylaw.
According to the town, there's a town bylaw.
Nobody told people at the pop sign.
So it's right here, 105, Article 6, controlled substances. No person shall smoke, ingest, or otherwise use or consume marijuana, tetrahydrocannabinol, as defined by MGL 94C, while in or upon any street, sidewalk, public way, footway, passageway, stairs, bridge, park, playground, beach, recreation area, boat landing, public building, schoolhouse, school grounds, cemetery, parking lot, or any area owned by or under the control of the town, or in or upon any bus or other passenger conveyance operated by a common carrier, or in any place accessible to the public.
Okay.
So,
Go ahead, Jim.
So it's a matter of enforcement. I mean, if the police department doesn't know there's a bylaw, then they're obviously not enforcing it.
Right.
So maybe we need to send a little missive over there to let them know that.
We don't need a public hearing.
Now,
we
is
won't
it
need
worth cleaning up these or not? It's time and
we can definitely clean them up if we can definitely clean them up, but we no longer need to add all these some little things here and there. But really, one of the things that we can do is, I know the town manager is looking to have a whole regulation review of all the town regulations, including Board of Health, and how they connect with town bylaws so that they are not in competition with each other, so that they're properly enforced. It's a project that's going to be done over the next year or so. So I would, based on this information that was given to me literally 5 hours ago,
well,
I would say we should hold off.
yeah,
on the
you
public
have
hearing.
enough to do.
Do you happen to remember when the next deadline is for state, this Cannabis Control Commission to start making decisions? Is it April of 2018?
I've heard April of 2018, which is
Dates,
which is why the moratorium was pushed.
Right.
April 1st of 2018, which is the reason why we have the fall town meeting to do our vote on the moratorium.
I can just add that as of today, town manager told me that the Cannabis Control Commission has not met to, the group that's going to develop all these, supposedly by March 31st, to be effective April 1st. So, that's why that moratorium, kind of regardless of what you think about, and I'm sure, my point for me, regardless of what I think about marijuana and the use of it, having a moratorium so we can all get all this stuff, because obviously that bylaw we just had, that's going to have to change. So that's, and there's going to be a forum. We don't have a date yet, public forum to talk about that town meeting articles relative to marijuana, their importance, and Libby said there'll be something sent out publicly to let people know about that.
Okay. All right, so we will not hold a public hearing in October on 72 and 73.
It's a good thing we didn't schedule it for today.
Director's report.
We have just closed out a new season where we've made it out alive. No small part on Art, Kathy, Hank, and Ann's work. And I was supposed to bring it today, and I left them on my desk. So I will send you via email the electronic copies of our strategic plan and community health assessment that we just finished. So it'll be open. It's definitely open for comments. We're not done because we need your input on it now. There will be signature pages so that everyone needs to be on board with it. We're really excited about it. We're very proud of this work. It's been a tremendous undertaking. It's basically consumed the work I've done and the work that my interns have done this last summer. I can't speak higher about them as well, and input of the staff as well. We are gearing up for the venison donation. Hank has been in conversations with Dylan Wallace and Mark O'Banion to do the work. Mark has offered to allow us to use, for Dylan to use his old scallop shanty area. It has a walk-in cooler. It's clean. It's permitted so that he can do the processing there. Dylan is okay with giving out his phone number so that you can call him, set up pickup. You can do it obviously day of. He will pick up the animal and bring it to the walk-in cooler and do the processing there. He is also looking to offer an incentive that we think is a great idea, that for every deer that you offer to the donation program, he will be willing to butcher another deer for personal consumption for free. Because more than anything, he and he said a couple of his chef friends want to practice knife skills. Since they're chefs already, it'll help them with their knife skills. So it's an incentive that we thought was great. So hopefully it'll boost the numbers this year.
Is this going to go into the paper so people know?
This will be put into the paper. We're just right now nailing down the details, getting a direct approval from Mark before
and
we.
Season is it October?
Art, you're the hunter here.
Well,
It's October, right?
we're still looking at shotgun. I don't know.
Archery, though.
October's archery season.
Archery.
This year,
Okay.
like around Homestead.
So we're trying to get that out. So and Dylan is willing to do the entire season from archery on. On the same notes, Martha's Vineyard has just had a hearing with the Division of Wildlife to possibly extend the hunting season by a week, the archery hunting season. So once we hear back from how that hearing came, it might be a good idea to pursue that and maybe even a second hunting season at that point. They've been kind of overwhelmed with the Martha's Vineyard requests right now. And then lastly, we just did marijuana. And then the other one right now is I've been working with the Fairwinds Health Center, the mental health center, formerly Family and Children's Services. We are in the midst of a mental health suicide contagion. Based on the 7 suicides this last winter, there have even in the past few months, there have been 63 mental health crisis situations where they have almost literally talked people off the ledge. So we have been holding bi-weekly meetings, or monthly meetings, sorry, specifically called the post-traumatic stress management meetings with DPH, DMH, the Board of Health, Gosnold, Fairwinds, A Safe Place, and the Julian Sears' office, Dylan Fernandez's office, and the churches as well. So we've been catching. That safety net has been in place, but the mental health issue is becoming an issue on the island.
Consistent theme?
In the suicides themselves, no. This year there was no connecting parts. So the first cluster from 10 years ago was teens. The second cluster was middle-aged white men. This year it's all over the board. So we don't. The suicides ranged from people's early 20s to 95.
But in the cluster of near misses, you say there were 60?
There were 63. I haven't seen the demographic data on that yet. I think they're still parsing it out. But yeah, the 63 number was given this past Monday at the meeting. And one of the things we're looking to do is now, with that, create a consistent area for conversation. So the Family Resource Center that they have just received some funding from the state, specifically for suicide prevention and drug abuse prevention. So one of the things that we're looking to partner up with is to create a monthly, hopefully ramping up to a bi-weekly forum where we talk about everything from community issues and all the family stresses and health stresses, all the way through to things like proper PPE for people doing de-lead work, because we've seen people not wearing their dust masks. So it's all sorts of things, reaching out to the tradesmen groups, because we realize that tradesmen have been neglected in some of our outreach, and we have the capacity to do it in multiple languages. Fairwinds has a 5-language capacity. So we're really excited for this new project, and I'm actually meeting with them tomorrow to hash out the details of this.
Great.
Any tick-borne disease numbers?
I should have run them. Yes, our numbers were lower this year from my conversation with DPH, because when Steve left, they've been trying to train Elizabeth Harris at the hospital right now to take over the Maven, the reporting portion. So in that meantime, the Department of Public Health has been keeping track of those numbers. And the last conversation I had with them last month, it's definitely, they said around a 10% reduction from last year, but I don't have that exact number with me. I'm sorry.
So it's hundreds, not 300s or 400s?
Yes, it's in the low hundreds again. Because the way the reporting was done originally was it was all suspect and revoked, and everything was in that number. Now they're strictly going by confirmed cases, so that we don't artificially inflate numbers accidentally.
Well, we probably artificially deflate numbers.
It's possible. I would say, because when you see the bullseye rash, there's no reason to do the blood test. The new protocol is to do the blood test regardless. But
it doesn't happen.
Yes. Oh, absolutely. We know that.
So
we know that. So
there's a lot of treatment on suspicion, period.
Even with the artificially deflated numbers, we still have the second highest tick-borne disease burden in the United States.
Yeah.
So even with the deflated numbers,
relative, it's high.
yes,
It's higher than it should be.
yes.
What else?
I think that's really it right now. Unless there's something
Ladies,
else.
gentlemen, anything else? Any other comments? We will We will see you all next week, and we'll look forward to October 17th to see if Hawthorne is fixed. I compliment the staff on that issue. I'm sure there was a lot of discussion about who said what, when, and where, but this was a 2-year 2 years should not have happened. There was plenty of time in 2 years to do what was done in the last 5 minutes.
That's right.
Yes.
So
And
you did, guys. You did fine.
yes, and I think on this one we've definitely learned that we will always communicate via email with particular people.
Fine.
The only thing that made me mad about the whole situation was they totally disregarded the problem.
Yeah, I know.
All right. If there are no objections, we'll adjourn the meeting.
Okay.